तो स्वागत है आप सभी का इस नए वीडियो में एंड इन दिस टॉपिक विल बी डिस्कसिंग अबाउट लोक अदालत. If you want the written notes to this topic, kindly visit our website legalvidya.com. So let's start with the topic. लोक अदालत is also known as people's court. लोक अदालत मतलब लोगों की अदालत, that is the people's court. It is a system of conciliation or negotiation. तो लोक अदालत में जो लोग होते हैं दे आर डायरेक्टली और इनडायरेक्टली अफेक्टेड बाय अ डिस्प्यूट और अ ग्रीवियंस और अ प्रॉब्लम बिटवीन देम एंड दैट इज व्हाई दे हैव अप्रोच्ड द पीपल्स कोर्ट और लोक अदालत. Lok adalats are established by the government to settle dispute through compromise basically. So, Lok adalats accept the case which could be settled by compromise and conciliation and are pending in regular courts within their jurisdiction. So, the first Lok Adalat that was ever held was in Chennai in 1986. Now, let's see the Lok Adalat under Legal Service Authority Act 1987. The section 19 of the Act, that is the Legal Service Authority Act, gives the center, state, and district to the power to establish Lok Adalat. Lok Adalat is a method of ADR or alternate dispute resolution. Their purpose is to settle cases that are pending or not have been heard before the common courts at all. Lok Adalat, they have a judicial officer or any person who is authorized under the jurisdiction of the state or central or local government. अब जब कोई भी डिस्प्यूट सुन लेती है लोक अदालत एंड उसके बाद जब वो अपना जजमेंट या डिसीजन देती है दैट इज बाइंडिंग अपॉन द पार्टीज एंड is handed down by a conciliators in accordance with section 21 of the act. और ये जो भी डिसीजन होता है इसे हम अवार्ड बोलते हैं. अवार्ड जो होता है इट हैज़ द सेम लीगल इफेक्ट एज अ कोर्ट्स डिसीजन. Scope of Lok Adalat. So Lok Adalat is not like Supreme Court. It has extremely broad. It is extremely broad to incorporate most of the cases pending before it, as well as the new cases जो उसके सामने आए. However, जो भी नॉन कंपाउंडेबल केसेस है दैट इज केसेस इन विच कॉम्प्रोमाइज इज नॉट एट ऑल पॉसिबल और विच आर ऑफ अ सीरियस नेचर, तो लोक अदालत उन केसेस को नहीं सुनता एज इट हैज़ नॉट बीन गिवन द jurisdiction for the same. Lok Adalat does not refer such matters to committees without giving the other party a reasonable opportunity to be heard. The Lok Adalat proceeds to resolve any case referred to it and tries to negotiate a mutually acceptable outcome between the parties involved in the case. Whenever a Lok Adalat decides a case before it, it adopts the most extreme efforts for a trade off or a settlement. तो लोक अदालत बेसिकली उसका एक ही काम है टू सॉल्व पीपल्स ग्रीवियंसेस by them agreeing on a mutually common ground. So, following points elaborate the scope of Lok Adalat. Now, let's have a look at those points. So, the first is if no settlement or compromise is reached by the parties after Lok Adalat passes, no order is given. A reference will be set automatically to the court that drew up the reference for disposition. Those involved in the dispute are urged to seek redressal in the court. If the terms proposed by the bench do not satisfy the party, the Lok Adalat cannot be forced to compromise or reach a settlement. Order from Lok Adalat are definitive and restrict the parties. That is, order from if Lok Adalat gives a particular order regarding a grievance, they are definitive and they are binding. फर्दर अगर लोक अदालत में आप अपने ग्रीवियंस लेके गए हो एंड यू एंड द अदर पार्टी आर नॉट एबल टू कम ऑन अ कॉमन ग्राउंड एंड कॉम्प्रोमाइज, then Lok Adalat cannot force the decision on you or cannot force you to compromise. An order passed by a judge is a satisfactory means of stopping the proceedings that demand justice. Lok Adalat have enough power under the Act, that is the Legal Service Authorities Act 1987, to make justice without compromising the equality of their award. The Lok Adalat's final order is considered judicial since it is given the status of a decree. A civil court recognizes it as a form of evidence and is given the power to summon, discover and get an affirmation. तो लोक अदालत के जो ऑर्डर होता है उसे डिक्री की वैल्यू दी जाती है एंड इट होल्ड्स अ जुडिशियल पावर. लोक अदालत को अंडर द एक्ट ऑफ 1987 एनफ पावर दी गई है to make a decision or to make a compromise without doing injustice. There's the case of P.T. Thomas versus Thomas Jobs 2005. In this, जो सुप्रीम कोर्ट है उसने लोक अदालत के बारे में एक्सप्लेन किया था. So, according to the court, Lok Adalat is an ancient form of adjudicating systems that once were predominant in India, and its validity has not been questioned even today. According to Gandhian principles, the term Lok Adalat means People's Court. It is an essential component of ADR, that is alternate dispute resolution. If the dispute is resolved at Lok Adalat, there is no court fee, and if it has been already paid, it will be refunded. Then there is another case of BP Mohiddin, Seva Mandir and others versus AM Kutti Hassan 2008. Just where it was said that the parties can communicate directly through their attorneys, which is far more convenient than speaking in a regular courtroom. Because Lok Adalats are dynamic, that is, they're always changing, they are able to balance the interest of both parties and pass order that can be accepted by both sides. Need for Lok Adalat. Simply put, when a person goes to a formal court, everyone knows it is a time taking process and also involves a lot of money. You have to give money to your attorneys, you have to pay court fees and all. But when you go to Lok Adalat, your grievances are instantly solved as well as your money is saved because Lok Adalat does not require a court fee. However, if you have already paid a court fee, it will be refunded as stated in the case already. Now we know that justice delayed is justice denied. The statement is true because we see there are a backlog of pending cases in our courts today. Now, this also results of delay of justice in India. Mounting area, areas of cases has brought judiciary and the judicial process at the verge of collapse. In India, Lok Adalat has, in the view of social goals of ending bitterness rather than pending disputes, resorting peace and family, community, or locality. Lok Adalats effectively deal with the magnitude of areas of cases, and today Lok Adalat is the only option left with which a person can resort their grievances by availing cheap and speedy justice. Functions of Lok Adalat. The members of Lok Adalat have to be impartial and fair. Lok Adalat is responsible for handling pending cases in the court. In case Lok Adalat in case of Lok Adalat settlement, the court fee paid in the court on the petition will be reimbursed. When filing a dispute in Lok Adalat, one does not have to pay court fee. So, for example, you're directly filing your dispute in Lok Adalat, then you do not have to pay a court fee. However, if your dispute which you have filed in the court is referred to a Lok Adalat, then जो भी आपने court fee pay किया, it will be returned to you. Types of लोक अदालत. तो जो लीगल सर्विस अथॉरिटीज़ एक्ट है उसके अंदर कुछ टाइप ऑफ लोक अदालत दिए हुए हैं विच आर एज फॉलोज. द फर्स्ट इज नेशनल लोक अदालत. तो ये जो लोक अदालत है इट इज़ हेल्ड इन नेशनल लेवल थ्रू आउट द कंट्री एंड by the Supreme Court and Taluka level adalats. Here, thousands of cases are disposed of every year. Every month, a different topic is discussed in this type of adalat. Then there is permanent lok adalat. The body is governed by Section 22B of the Legal Service Authorities Act. There is a mandatory pre-litigation mechanism in permanent lok adalat that settles dispute concerning public utility. तो लोक अदालत में बेसिकली जो डिस्प्यूट आते हैं दे रिलेट टू ट्रांसपोर्ट, टेलीग्राफ, पोस्टल सर्विसेज, इलेक्ट्रिसिटी एक्सेट्रा, या फिर जो भी पब्लिक यूटिलिटीज आपके दिमाग में आ रही है, ऑल ऑफ देम. Then, as a result of the case of Abdul Hassan and National Legal Service Authority versus Delhi Vidyut Board and others, 1999, the permanent lok adalats were established. So, जो permanent lok adalat hai, as I've already stated, they are bound to resolve public utility disputes quickly. Therefore, if parties neglect to show up at the settlement or compromise, then it has further advantage of choosing the dispute on a merit. In this way, the possibility of postponement in the resolution of questions is eliminated. Then we have mobile lok adalats. Mobile lok adalat is a method of settling dispute that travels from one place to another. Over 15.14 lakh lok adalats have been held in this country as of 30th September 2015, and 8.25 crore cases have been settled. Then there is Mega Lok Adalat. Mega Lok Adalat is an ad hoc body that is constituted at state level on a single day in all courts. Then we have daily Lok Adalat that are held on daily basis, and continuous Lok Adalats that have been held continuously for a specific number of days. Then coming to our important topic of jurisdiction of Lok Adalats. Lok Adalats fall under the jurisdiction of the court which organize them, and thus they cover all the cases heard by that court under its jurisdiction. तो ये जो jurisdiction है, it does not apply regarding offences which are not compoundable by law, as we have already stated earlier. The respective courts may accept cases presented to them by parties, concurring that the dispute should be referred to the Lok Adalat. The courts may accept such cases in situations where one party makes an application to the court for the referral of the case to the Lok Adalat, and the court might consider that there is a possibility of compromise through the act. तो लोक अदालत का jurisdiction क्या आता है? लोक अदालत जो भी कोर्ट ऑर्गेनाइज करती है उसके अंडर आता है. सो एनी केस दैट इज, for example, there in the high court, and there is a lok adalat of that particular high court, then lok adalat has the jurisdiction to hear that case. However, if the case is non-compoundable, that if it is a serious offense or if it is very grievous in nature, then it cannot be compounded and lok adalat को उस केस का jurisdiction नहीं दिया जाएगा. That's it for the topic. I hope you all learned something today. Thank you.